this. Normally, you get this associated with some other center, like it can be a part of some other center, but this is a full-fledged inter-university consortium.
Yes, sir. Yes, sir.
It is wonderful, ma'am.
So I shall wait, sir, and then after the...
Yes, ma'am. We are starting right away.
Okay, sir. Okay.
Sure. Okay. Good morning, friends. It is a very pleasant day here at RC Trivandrum. The climate is also very pleasant, and I have been informed by my staff members that many of our students as well as officials are joining from across the country for this webcast. I thank each and every one of you for having spared your valuable time to join this session, and I also thank in advance all others who will be joining this very important session today, and I'm sure all of us will be gaining a lot of information, a lot of ideas, a lot of thought processes will be going on in our mind once we come to the end of this session. It is my absolute delight and privilege indeed that we have a luminary in the field of legal studies, that is Professor Dr. Vani Kesari, who is at present the Honorary Director of the Interdisciplinary Center for Research, Ethics and Protocol at the very prestigious Cochin University of Science and Technology. In fact, Madam has had a number of responsibilities about which we will be talking in an elaborate manner in a short period of time. And in fact, we are in fact very fortunate that Madam has been able to spare her very valuable time on this day, in spite of this being a working day, to share her thoughts on a very, very vital and important topic, which is so significant for our polity and country as such, that is the originalism versus living constitutionalism, reflections on the Indian Constitution. That's a wonderful topic. And the moment Madam suggested this topic, a large number of ideas, large number of issue areas just came into my mind. In fact, I was taken back to some of my lectures and classes in during my LLB period, and a lot of aspects came to my mind quite instantaneously. We all know, and it is a fact to state that Constitution lives through the judicial pronouncements. And therefore, there's an intricate link between the judiciary as well as the Constitution. And if you look at the kind of interpretations that have come over the years, we'll find that the Constitution has been given a great deal of strength through judicial pronouncements. Now, if we start right at the beginning from in fact, it's not the beginning, but the most important case for quite a few reasons, the Keshavananda Bharati case, where the basic structure of the Indian Constitution was enunciated, that itself was a landmark strengthening of the Indian Constitution as such. Similarly, you have the state of West Bengal versus Union of India, where the federal structure of the Indian Constitution was enunciated. Then you had the landmark Maneka Gandhi case, where the expanded interpretation of life and personal liberty as such was enunciated by the judicial luminaries of our country. Then we have a large number of large plethora of cases, including the Minerva Mills case, the Rajnarayan, Indira Gandhi versus Rajnarayan case, the Golaknath case, and so many other recent cases as well, which in fact has strengthened the Constitution in innumerable ways. Today, we are going to have a feast. All law students and non-law students will be having a feast when many aspects related to the Indian Constitution, the way it is actually working, the contours of its functioning, everything will be explained threadbare and in great detail by our very, very visionary and very articulate resource person that we have today, Professor Dr. Vani Kesari. Of course, her achievements span a number of areas, and therefore it deserves a bit of elaboration. For doing the same, I would now like to welcome our Assistant Regional Director, Dr. R. Raja, for giving an elaborate view of Madam's achievements and accomplishments. And before handing over the stage to Dr. Raja, Sri Raja, I would like to welcome our Assistant Regional Directors, Dr. Priya Pradeep, our Assistant Registrar, Dr. Sri Raja, all the staff members at the regional center, all regional directors, assistant regional directors, other functionaries who are joining from other regional centers from across the country, our academic counselors, coordinators, and all functionaries at the regional centers as well as at the study centers who have taken their valuable time out to attend this program. We also welcome the participants on YouTube as well as Facebook, where this program is going live. And therefore, we have a good number of participants in this particular session. And I'm sure during the interaction phase, there will be a lot of discussion on very many vital areas. So without much ado, let me welcome Sri Raja, our Assistant Registrar, to introduce our very, very erudite guest of the day, Dr. Professor Vani Kesari. Over to you, Rajaji.
Thank you, sir. A very pleasant good morning to everyone, and a special thanks to Dr. M. Rajesh to giving me an opportunity to give today's wonderful welcome address. A very warm welcome to all who present here across the country for the wonderful webinar on Originalism versus Living Constitutionalism, Reflections in Indian Constitution. Concept, a theory of the interpretation of the legal context, text including the text of the Constitution. A special thanks to welcome to our guest of the day. I am delighted to introduce our guest and most respected Professor Dr. Vani Kesari A, Professor and Honorary Director, Professor N.R. Madhava Menon Interdisciplinary Center for Research, Ethics and Protocol, ICREP, an inter-university center of excellence established by Government of Kerala, and former Director, School of Legal Studies, Cochin University of Science and Technology. And Madam's education qualification. It is really, this is the first time I'm seeing such a beautiful elaborative information. Madam's PhD in Faculty of Law from Cochin University of Science and Technology, and awarded on 17 February 2016. And LLM, PG, LLM, Constitutional and Administrative Law, second rank holder from Department of Law, University of Kerala on December 1998. And LLB, 5 years integrated program from Government Law College, Trivandrum, University of Kerala during 1996. And Madam's teaching experience, 17 years of teaching experience at permanent university services, inclusive UG and PG. And apart from that, another 22 years of total experience as both permanent and contractual faculty. Apart from the teaching, Madam practiced as an advocate in Honorable High Court of Kerala from 1999 to 2000. And teaching courses offered by postgraduate level, that is Constitutional and Administrative Law, Human Rights Law, Comparative Public Law, Humanitarian Law, Bioethics and Health Law, N number. And in respect of research experience, Madam has awarded a PhD on 17 February 2016 for the thesis titled Sanctity of the Human Life in the Context of Human Genetic Research under the guidance of Dr. N.S. Soman, Associate Professor, SLS, QSAT, and recognized guide of the university since 2016 with 4 scholars pursuing research under different streams of law such as human rights law, maritime law, etc. That is, business on nautical matter, shipping or offences occurring in open water. Madam has done a beautiful maritime law. And presently, 4 research scholars registered under Faculty of Law, QSAT, are being guided. Current status, Madam has awarded PhD award to Srimati Anna Laurette Korea, and second person Sri Nandu Sam Jose. And Madam as an accomplished individual in various fields and a key factor, that is designing of academic courses and course coordinator for academic programs at CREP, and participation of state level governing bodies, Kerala State Higher Education Council and Cochin Cancer Center, Cochin. Madam has participated at university level governing body for more than 25 institutions, expert guidance, national and international level. And Madam has been an examiner of PhD, UG, PG, MPhil and Kerala Public Service Commission. It's a great Madam. And Madam received many award distinctions, consultancy work for KINFRA. And Madam has published journals and magazines and books, and articles in proceedings of seminar, editorial, board, reviewer, present positions. And Madam worked as a faculty researching programs, and also as a resource persons in training programs of faculty recharging. And at the same time, Madam is invited for law schools, higher education and research institutions, and also a project seminar, organizing coordinator seminar. And Madam has acted as a resource persons, paper presenter, chair in national and international seminar workshops from 2008 till date. And many more accomplishments and achievements are there. Due to time constraint, we could end here. And congratulations, Madam, on your well-deserved success. And thanks for warmly accepted our invitation to join us today's event. And on behalf of Indira Gandhi National Open University, Regional Center Trivandrum, I would like to extend my heartfelt gratitude to our esteemed guest on this wonderful morning. Once again, thank you, Madam, for your benign presence. Now, over to Madam, and Madam has to present a beautiful presentation. Pranam, Madam, Pranam.
Good morning, all. Esteemed Senior Regional Director of IGNOU, Trivandrum, Dr. M. Rajesh, Shri R. Raja, Assistant Registrar, IGNOU RC Trivandrum, as well as Dr. Priya Pradeep, Assistant Regional Director, IGNOU RC Trivandrum, all the learned participants of this Constitutional Day Celebration Week, all those who have joined in the Facebook and YouTube. A warm welcome to all of you, as well as the greetings from my side. Friends, I'll be sharing my PPT so that we can have a discussion and you understand the underlying currents of this discussion. I'm told that there are participants who don't belong to the legal fraternity, who are the general layman, and I think that every citizen of India, apart from being a law student or not, should be aware of the constitutional constitution and constitutionalism in general. And that is the reason why this particular discussion has come up. So kindly bear with me, spare me a few seconds so that I can share my PPT. Is my PPT visible to all of you?
Yes, ma'am, it's visible.
I'll just put it in my
Full screen mode.
full screen right now.
That will be great.
So shall we begin?
Yes, Madam. Yes, Madam.
Yes. Friends, you find that this is one of the important areas which is also often been reflected and discussed in most of the law schools. But unfortunately, you find that constitution becomes the main thing, and rather than constitutionalism being given more importance to. And that is precisely why I have chosen this particular topic during my interaction with Dr. Rajesh, wherein I said that originalism versus living constitutionalism needs more discussion as far as its impact on Indian constitution. Friends, with your permission, I'm going to the discussion as such. Let me begin with the question as to why this discussion, in fact, has prompted it. This is a famous adage.
Sorry to interrupt you, ma'am. The slide is not moving, I suppose.
Okay.
Hello.
Is it moving right now, sir?
No, ma'am, it's not moving. It's not in the full screen mode. What I suggest, let it remain in this mode itself, ma'am. You can click on the slides and then explain that. Then that will be easier.
Okay. So, I think there's some problem with Google Meet when you
Yes,
share.
there is. Sometimes it happens.
Okay, sir. So since there's no other way out, I will just share my views on this. So I'll come to the question as to why this discussion. Friends, for that particular answer lies with the formal, very famous adage or a quote from the Constituent Assembly debates given by Dr. B.R. Ambedkar, the chairman of the drafting committee of the Constituent Assembly of India. Constitution is not a mere lawyer's document. It is a vehicle of life, and its spirit is always the spirit of age, which means that Constitution is not a mere document. It's not precisely for the lawyers alone to ponder, but it is a vehicle of life. So Constitution has a life of its own, a spirit of its own, and that spirit is being reflected by this changing times or the spirit of the age.
Okay.
Now, the discussion here would be focused on 5 main areas as to what is Constitution and how is it different from Constitutionalism, what is Originalism and its difference with living Constitutionalism, the American experience and the Indian manifestation of it. Friends, a simple and a general definition as to what is Constitution. A constitution is the basic or the fundamental legal framework which lays down the structure, powers, and functions of the state and includes the rights and duties of its citizens. So, friends, you find that the simple definition of constitution is it is a fundamental legal framework upon which the superstructure, that is the governments, which comprises of the central government or the state government or the local bodies, what are their powers, what are their functions, and it also encompasses the rights and duties of the citizens. So why do we need a constitution, or why a constitution? If you look into this particular question, the natural answer for it is that it is usually associated with time in which a particular state is formed or associated with a major change that has taken place at national level. Now let's look into this particular premise on the basis of actual practical experience. If you look into the constitutions of Italy and Germany, you find that the new constitution was crafted in Italy and Germany in 1948 and 1949 respectively after their defeat in the World War II. And it also marked the destruction of the previous regimes. If you look into the US Constitution, how the US Constitution, which is one of the oldest constitution in the world, was being crafted soon after America attained independence over the British colonization in 1787. If you look into how the Indians drafted the constitution, again, as that of the American experience, India happened to draft her constitution soon after her independence in 1947, and you find that the Constituent Assembly being framed, and finally you find the constitution coming into force in 1950. A general glimpse of what are the basic characteristics of the constitution is inevitable to have an understanding of the discussions which we are going to conduct here today. Undoubtedly, it is a fundamental law of the land. Every constitution. Anything to be conveyed to me, sir? Okay. So it is a fundamental.
No problem.
Okay. It is a fundamental law of the land. Any constitution need not be written always. It can also be an unwritten constitution, as you find in the British Constitution. And undoubtedly, the constitution should deal with the structure and power of the government, the rights of the citizen, and the relationship between the government and the people. Finally, one cannot deny the fact that it is the supreme law of the land. Whichever country has a constitutional democracy, there the constitution is the supreme law of the land. Now let's look into the types of the constitution. Friends, I'll give you a gist of what are the different types of the constitution. Written constitutions or codified constitutions are contained in a single document, that is the American Constitution or the Indian Constitution. Unwritten constitutions or uncodified constitutions are spread across multiple documents and are based on historical precedents, legal conventions, and judicial decisions. Example, Britain. So if you look into the British Constitution, it's an unwritten constitution. It is based on the convention or the parliamentary conventions, the practices which were being followed in Britain, the precedent, that is the judicial decision making made by the common law courts. So it is scattered. In Britain, the reason why there is no written constitution is that they are both historical and conceptual. British history has remained continuous since 1689, and there has not been an obvious break which could have been called for drafting a codified constitution. Now let's look into the next type, that is rigid and flexible constitution. Constitutions which can be amended easily are known as flexible or simple constitutions. Example, the Canadian Constitution. On the other hand, constitutions that have a special procedure for its amendment are considered as rigid or complicated constitutions. Example, the US Constitution. So you find that since the inception of the American Constitution in 1787, only 27 amendments have been made hitherto.
No.
What is the status of the Indian Constitution? Usually, scholars term the Indian Constitution to be partially rigid and partially flexible. However, you find that the Indian Constitution, since its inception in 1950, has undergone 118 amendments as of now. Now, let's look into the other type of constitution, that is federal and unitary constitution. A federal constitution refers to one in which the government powers that exist in the country are shared between the central and the state government. Example, the American Constitution. And a unitary constitution refers to one that concentrates the government's power in the central government. Examples are Britain, Italy, France, and Belgium. Now let's directly venture on to the meaning and content of constitutionalism. Friends, you find that none of the constitutional experts or jurists have been able to give a clear-cut definition to the terminology constitutionalism. But constitutionalism needs to be understood as a fundamental or the underlying values, principles, theories, and philosophies which limit the power of the government by law. So you find that constitution is something, a document, whereas constitutionalism is something, a value precept or a concept or a group of principles or theories which are articulated or which are lying underneath the constitution, and it presupposes the limitation on the power of the government. Now let's see what is the difference between constitution and constitutionalism. Friends, as I've already stated, constitution is a formal document which outlines the fundamental principles and structures of a government, whereas constitutionalism is the ideology and practice of limiting the governmental power through the means of constitution. So the principles of the constitution are being termed as constitutionalism, and the means by which the principles come to reality is through the constitution. So constitutionalism emphasizes the adherence to constitutional principles. While the Constitution provides a legal framework, constitutionalism ensures that this framework is respected and upheld at all times in actual practice. Now, some interesting questions for all of us to ponder on. The question always arises whether these rights and liberties are frozen at the time when the Constitution was framed. Friends, all of us know that most of the written constitutions recognize a set of liberties and rights for the citizens, as well as non-citizens. Now, the fundamental question before us is that, are these rights to be kept frozen as laid down in the written words of the Constitution, or should it evolve with the changing times? This question has to be answered mainly by the courts, because you find that the courts are vested with the responsibility of interpreting the wordings in the Constitution. So they are the interpreters, while you find that the executive or the administrative side enforces the law and the legislature lays down the law. In fact, the judiciary is the interpreter of the law. So any administrative action or a parliamentary or a state legislation passed by the competent legislature needs to be scrutinized on the touchstone of the Constitution. So judiciary becomes an omnipotent, exercises its omnipotent presence through interpretation process. Now, recently in 2022, you find that the American Supreme Court happened to decide a question as to the legality of the abortion right, which was being judicially conferred to the woman way back in 1973 in Roe versus Wade. So the Supreme Court of America in 2022, in the famous Dobbs versus Jackson's Women's Health Organization, held that it mainly depends, the court negatived the contention that women do have the right to abortion. So it turned out a decision which was taken by the US Supreme Court years before, and it came out with the conclusion that the women do not have a right to abortion. And the court said that the courts have the privilege to decide a constitutional provision based whether to go in for the original text or to the a more transformative jurisprudence, a more emancipated or progressive outlook. And in fact, you would be surprised to see that in Dobbs versus Jack's Women's Health Organization, the court negatived the right of the women to go in abortion, sticking on to the fact that the American Constitution does not provide an express right, that is, a right given in express terms, written terms, or a right to abortion for women. And thereby, you find that the court stuck to the position that originalism is to be followed. Now, we need to understand this particular dilemma which the American court faced if we need to look at the way in which the Constitution has been interpreted from earlier times. For that, we need to understand that there are two main ways of interpreting the Constitution. The first being originalism, that is, to interpret and enforce the Constitution as it was understood at the time it was originally written. The two crucial components of originalism are that the claims that constitutional meaning was fixed at the time of the textual adoption, and the discoverable historical meaning of the contextual text has a legal significance and is authoritative in most circumstances. Friends, you find that the originalists want the intent and the idea of the makers to be given paramount importance. I will explain to you this particular aspect. That is, when a particular constitution is being adopted, the interpretation which the originalists would choose is that you go by the textual meaning which the constitution framers would have given meaning to at the time of framing the constitution. So when you have a intent claimed to be by the framers of the constitution, please go by that meaning. And the courts are not expected to go beyond it or give a creative interpretation to the textual meaning which was adopted or articulated by the framers of the constitution. So originalism is giving the intent and the idea of the makers of the constitution a more prominent view, and the courts are being restrained to give a creative interpretation to the words in the constitution. Now, the next aspect is living constitutionalism. Living constitutionalism, on the other hand, is commonly associated with the modern jurisprudence. The proponent of this theory believes that the legal content of constitutional doctrine does and should change in response to changing circumstances and values. The Constitution cannot be static for all time to come. It has to match with the needs and beliefs of the future generation. A living constitution is one that evolves, changes over time, and adapts to new circumstances without being formally amended. So the judiciary has a responsibility to see that the words in the constitution are being interpreted creatively to keep in times with the demands of the day and along with the spirit of the constitution. So while you interpret a particular word in the constitution, take for example the right to life under the Indian constitution, you would find that a creative interpretation has been given by the constitution to include a gamut of rights. So right to life includes right to speedy trial, right to fair trial, right of the prisoners, rights of the accused, rights of environment, right to environment, right to education, right to privacy. And of late, you find that right to clean drinking water and right against climate change has been recognized as a part of right to life. This is through a creative interpretation. And you find that the Indian Constitution has the interpretation given by the judges has given a far-reaching effect to the words in the Constitution. Now, let's have a glimpse of the American experience before venturing on to the Indian experience and its manifestation. Now, friends, at least those in the legal circles would be aware of the famous case of Griswold versus Connecticut, wherein the Supreme Court of America upheld the right to purchase and use contraceptives and thus consolidated the right to privacy, not expressly written anywhere in the Constitution. So, in Griswold versus Connecticut, the Supreme Court of America recognized the right to privacy, though it is not in any sense written down in the Constitution. Again, you find that in Obergefell versus Hodges, which is a 2015 decision, the Justice Anthony Kennedy, upholding the same-sex marriage, went on to assure that changed understanding of marriage are characteristics of a nation where dimensions of freedom become more apparent to new generation. The court held that the Constitution does not freeze for all time the original view of what those rights guarantee or how they apply. Again, recently in National Labor Relations versus Noel Canning, the court remarked that founders knew that is the founders of the American Constitution, knew that they were writing a document designed to apply to ever-changing circumstances over centuries. And therefore, you find that creative interpretations are to be applied since American Constitution is a living document or a living tree. Surprisingly, you find that The recent trends in America, as discussed before, you find that Dobbs versus Jackson Women's Health Organization has taken a strong tilt towards originalism. The court overruled two of its earlier decisions, famously known as Roe versus Wade of 1973 and Planned Parenthood of Southeastern Pennsylvania versus Casey, holding that US Constitution does not confer any right to abortion. The court, speaking through the majority, remarked that the Constitution makes no reference to abortion and no such right is implicitly protected by any constitutional provision. And this again raises a question of where are we heading to? Now, as discussed in my previous slide, I told you that this American experience, has it got any connection with the Indian constitutional experience, would be a subject of interest to all of you. And so we will be discussing it in the next half of the presentation here today. Before that, let me give you certain interest. Let us discuss certain interesting facts about our constitution. Friends, Indian Constitution, as all of you know, was adopted in November 26, 1949. And it came into effect on January 26, 1950, which is celebrated as a Republic Day in India. Now, our constitution is the largest as well as the longest in the world, and ours is the largest democracy in the world. And our constitution comprises of 146,385 words. It has 444 articles, segmented into 22 parts and 12 schedules, with 118 amendments to date. Now, certain interesting facts again. Both the Hindi and English versions of the constitutions were written in original texts, which were handwritten by Prem Bihari Narayan Resta. Prem Bihari Narayan Resta. A total of 3 reading sessions were held to discuss the draft constitution before it was finally passed on November 26, 1949. To be precise, it took 2 years and 11 months and 18 days to complete the final draft of the Indian Constitution. Now let's look into the journey of the Indian Constitution and how has it accommodated living constitutionalism. The Constitution of India, as it is now understood and interpreted, is a living document. However, that has not been the case always. So you find that again, the question of as to whether we are sticking on to originalism or are we migrating to living constitutionalism has gained momentum. The cases which were decided immediately after the Constitution was enforced gives an indication that Constitution was interpreted as per the intent of the framers. Thus, initially, originalism was a common followed path. Friends, all of you might be aware of this famous decision, A.K. Gopalan versus State of Madras, which is reported in 1950. This case revolved around the Preventive Detention Act of 1950, which allowed the government to detain individuals without trial if they are deemed to be a threat to national security. A.K. Gopalan, a communist leader, challenged the constitutionality of this law. In a unanimous ruling, the Indian Supreme Court upheld the law and ruled that citizens could be detained without a trial if they are considered to be a threat to national security. Now, if you look into the slide, Article 21 has been given, and the bare reading of the words in the Constitution is such: no person shall be deprived of life and liberty except according to the procedure established by law. So the wording is except according to procedure established by law. So any law can be made and a procedure can be made wherein you can preventively, you can use this particular law and detain a person if it is a preventive detention law. So now the question is, whether the law should be just, fair, and reasonable. The court said that the law need not be just, fair, and reasonable. Only that there should be a procedure established by law. Because the court's justification for this was that we do not follow the American due process clause. And so the question is whether there is a compliance of the procedure as established by law when an individual is being detained under the preventive detention law. So this was a famous case of A.K. Gopalan, wherein you find that the textual meaning of the word, except according to procedure established by law, was followed. Well, after 28 years, the Supreme Court of India overruled the A.K. Gopalan decision, and in Maneka Gandhi versus Union of India 1978 decision, accepted the argument, that expression that procedure established by law should be just, fair, and reasonable. Friends, as all of you might be knowing, aware of this particular case, as per 10(3)(c) of and B of the Passport Act, Srimati Maneka Gandhi, her passport was impounded, and which she challenged before the Supreme Court of India, saying that there was no compliance of procedure, and the procedure was she was not being given a fair hearing before impounding her passport, and the Supreme Court came to the rescue and said that the procedure established by law should be just, fair, and reasonable. Now, again, if you look into Article 21, wherein, especially with regard to the question of right to privacy, because I'm taking just one particular right, because there's paucity of time for entire discussion. Of course, we can have a deliberation and discussion post this presentation. You find that the earlier views in Karak Singh versus state of Uttar Pradesh, wherein the Supreme Court invalidated night domiciliary visits by policemen to persons classified as habitual criminals, but the court said that the right to privacy is not a guaranteed right under our constitution, and therefore the attempt to ascertain the movements of an individual, which is merely a manner in which privacy is invaded, is not an infringement of a fundamental right guaranteed by Part 3. Similar such views can be found in another case which was decided in 1954, MP Sharma versus Satish Sharma. So again, you find that the court coming and saying that, no, we do not think that Article 21, right to life, includes right to privacy. All of you might be aware of the famous Aadhaar case, that is Justice K.S. Puttaswamy, retired Justice K.S. Puttaswamy versus Union of India, which is a 2017 decision, wherein the Attorney General, relying on the above two decisions, contended that is the Karak Singh's decision and Sharma's decision, contended that the framers of the Constitution expressly rejected the right to privacy being part of the fundamental rights under Chapter 3 of the Constitution. However, the court sprung to the occasion and emphasized that the Constitution must be interpreted to respond to the changing needs of the society at different points of time. Thus, the right to privacy was being recognized as a fundamental right, and the court overruled its decision in Karak Singh and MP Sharma. The next important decision which I would like to cite in this discussion here today is the Supreme Court Advocates and Record Association versus Union of India. I would just take the quote of the decision. That is, the quote goes like this: the proposition that the provisions of the Constitution must be confined only to the interpretation which the framers with the Constitution and the outlook of their time would have placed upon them is not acceptable and is liable to be rejected for more than one reason. So the court came up with the reason why we need not go by original text or originalism, but we should interpret based on the aspirations of the time and the document. So the first reason pointed out by the court was that some of the current issues could not have been foreseen by the framers. Secondly, others would not have even been discussed by the framers in the Constituent Assembly. Thirdly, still others may be left over as controversial issues. So that is termed as deferred issues with conflicting intentions. So you find that creative interpretations or interpretations by courts based on with the passage of time and requirement is inevitable for the Supreme Court. As Rajesh sir was aptly referring to the basic structure doctrine, which is again a judicial creativity, you find that I will just go to the quote given by the 13-member bench of the Supreme Court. The court said that Constitution is expected to endure for a long time. Therefore, it must necessarily be elastic. It is not possible to place a society in a straitjacket. The society grows, so are its requirements. The Constitution and the laws may have to be changed to suit those needs. No single generation can bind the course of generations to come. So friends, we are coming to the conclusion of my discussion here today. Are we on the right track? Should we stick on to originalism or should we go to living constitutionalism? I believe that the interaction after my presentation here today would give a meaningful answer to it. But at present, we need to confess the fact that the debate continues, either it is in America or it is in India. So my conclusions and my opinions with regard to this is that India is a land of pluralistic society where people with diverse culture and traditions enjoy camaraderie among themselves and coexist peacefully. The courts need to adopt a liberal and pragmatic approach and need to give life to constitutional provisions. Constitution is a living organism. It is not with the changing times the meaning changes, but changing times illustrate and illuminate the meaning of the expressions used in the Constitution. The connotation of the expressions used takes its shape and color in evolving dynamic situations. The Constitution will become a stale and a dead testament without dynamic, vibrant, and pragmatic interpretation. So that's it. Thank you. Thank you so much for your patient listening.
Thank you so much, ma'am. It was a wonderful session. In fact, I should rather say that we have been given a full lunch when we were expecting a breakfast. It was wonderful to listen to you. As always, there are a number of issue areas you have dealt with. You have definitely touched upon the very important aspect of how Indian Constitution is very much living, thriving, and succeeding in various aspects. How the judiciary is adding essence to what the constitutional framers had thought of in their minds. And definitely, this is one discussion that will go do a great deal of favor to actually bring forth the various issues that confront the Indian polity as such. Thank you so much, ma'am, for that wonderful presentation. As always, it was a pleasure listening to you. And as former students of CUSAT, School of Legal Studies, we are indeed privileged to listen to your session once again, ma'am. In fact, we are joined by a large number of highly accomplished academicians as well. So I'm sure the discussion will be very vibrant and fruitful. I will start one with myself. Madam, you have given a large number of instances in which the Constitution has been interpreted and various additions have been creatively made by various courts of the country. Now, my specific doubt is whether the original philosophy, the original sentiments of the Constitution makers have been taken care of in the kind of decisions that have come over a period of time. Or have there been variances? What is your take on that, ma'am?
So in fact, that is what I was pointing out. The court would consider as to what is whether to give a textual meaning or intent which the constitution makers have done. That is, they would rely on the Constitutional Assembly debates which were taking place or other documents which are available in the public domain to come to the conclusion was what is the intent behind the particular expression in the Constitution. So I was giving the example of right to life or dignity or something like that, and then going and carving out or giving an interpretation. You asked me a very poignant question. Let's take an example of freedom of religion. So freedom of religion, when a question came up before the court that whether a particular practice should be considered as the part of a religious practice, the court carved out the test of essential religious function. And the court said that we need to understand that we need to look into the historical, the cultural traditions of that particular religion or that particular community, and then come to the conclusion that whether a text, the historical text, the religious text, etc., and come to the conclusion as to whether this particular practice comes within the ambit of the individual citizen to express his freedom of religion. So the essential religious function test was carved out. Of late, you find that there's some sort of confusion as to cases in which essential religious function test can be applied. So the basic example is that of the Indian Young Lawyers Association case, that is a famous Shabarimala decision, wherein the court was confused as to what is to be done. So, in fact, you find this friction going in and around. So, I didn't want to express all these things, but then this is an inherent tension which you find, and you cannot say that that is not there. But you find that there's an evolution of transformative constitutionalism, which is a slight different from the living constitutionalism, where you find that the society needs to transform, and the transformation needs to be done in a progressive way, wherein you find that you're giving color or to a word in a constitution, so that we have a peaceful coexistence. So that's how it is being. It is something, a balancing of interests which the court undertakes.
Thank you, ma'am. Thank you. Now the floor is open. I think there is one question in the chat. Stella Nandu, she's asking the question, a clarification regarding to what extent does the principle of judicial activism in India reflect the shift towards living constitutionalism, or does it adhere to the originalist intentions of the framers of the constitution? It's
Yes, very significant and very important question, madam. You find that living constitutionalism is at times pushing the courts to extreme judicial activism, I would say. Whether it is needed or not, that is a question to be, there needs to be a self-introspection by the courts themselves. But the factual situation is that living constitutionalism has definitely led to judicial activism.
Thank you, ma'am.
Good afternoon, sir, and good afternoon, madam.
Dr. Pramila is our Assistant Regional Director from RC Patagara. Welcome, ma'am.
Yeah, thank you, sir. Thank you very much. It is very informative, and very thank you all for providing us such a chance to interact with you all. And especially, I have a small doubt regarding what role does the preamble of the Indian Constitution play in bridging the gap between originalistic and living constitutionalist views, especially shaping in the vision of justice, equality, and liberty, madam? That is my doubt.
Very nice question, ma'am. As a student of law, I would like to answer that also.
Yeah.
In the sense that I would say that in Keshananda Bharati's case, as well as followed by various other decisions, you find that the preamble is part of the basic structure of the Constitution. So you find that all the value systems which have been declared by the Constitution, such as justice, which includes economic, social, and political justice. You find fraternity, equality coming in. All of them are open-ended concepts. If you look into what is equality, we will not be able to define what is equality. If you are asking me the question as to what is dignity, you would say that me and you are human beings, and so respect of individual worth is human dignity. So it is being given a wide array of value precepts have been included in the preamble of the Constitution, and that is precisely why the interpreters in Keshananda Bharati's case, that is the 13-member bench of the Supreme Court in Keshananda Bharati's case, happened to say that they are part of the preamble is part of the basic structure theory, and they cannot be amended or taken away by a constitutional amendment by the parliamentarian sitting in the parliament. So that's, I think I have answered your question.
Thank you, ma'am. There is another.
Yes, ma'am. Yes, ma'am. Yes, ma'am. Thank you, ma'am. Thank you, sir.
Thank you, ma'am, for that question. In fact, there are two questions on the chat. Can Shiba B? She's asking the question: can the Constitution be a hybrid of originalism and living constitutionalism?
Yes, there are systems which. Indian constitution is also can be termed to be at times, when you look into it, initially going in for originalism. So it depends on, the court's attitude, the judge's attitude. At the end of the day, you need to understand that judges are also human beings. So you find that their prejudices, their likes, their dislikes gets reflected in the judgments. So you find that, and their way of interpretation also gets reflected in their thought process also gets reflected in the judgment. Of late, you might have undergone, you might have read the controversy with regard to the Justice Krishna Iyer's doctrine, and that has been criticized of late. So the question is, they are trying to introspect as to whether their decisions were right or wrong. And that is a continuous process. We live in an enlightened democracy, and judiciary is also evolving itself. Judicial principles also needs to be evolving. So let's take it in a very, 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 very positive way, that our judiciary is making all efforts to make a self-introspection, looking into ideals, whether there needs to be a relook into the certain principles. Okay, let's see that. And of course, we are not absolute. There might be changes. So Constitution, say division bench of the Supreme Court is susceptible to full changes being made by the Constitution bench. So let's hope it in that way. So the next question, I believe, sir, it's from CG.
Yeah, it is from CG Ratish. She's asking the question: given the socio-political evolution of India, how might the originalism versus living constitutionalism debate apply to the interpretation of Article 368, which deals with the amendment of the Constitution? Should constitutional amendments be confined to the original meaning, or should they adapt to changing societal needs?
Let me make one thing very clear to you. The controversy with regard to originalism and living constitutionalism is exclusively related to judicial interpretation. Let's not confuse ourselves with legislative actions or administrative actions.
Yeah.
So we shouldn't confuse it with that. Now the question is whether the intent behind the particular words in the Constitution should be stick on to the original intent which the Constitution makers gave, or it should be evolved, or can the judiciary be given the freedom to evolve it based on the changing needs on a practical plane. So that is a question, and not with regard to amendments. So please don't confuse that with this.
There's another question by Afsana Majid. She's asking the question: does the Indian judiciary's interpretation of the Constitution over the decades indicate a preference for evolving interpretations, that is, living constitutionalism, or does it reflect commitment to the original intent as is envisaged by the Constituent Assembly?
That is what I'm saying, that I was trying to impress on all of you that there has been a preference, evolving preference towards living constitutionalism. I need to admit that. Now that the latest phenomenon is global constitutionalism, I'll just go, since Afsana, I think I can also add to that, because global constitutionalism is nothing but with the recognition of human rights jurisprudence all across the globe. Most of the constitutional democracies in the world have given light to certain fundamental rights in the ambit of human rights jurisprudence. So you find that a lot of human rights instruments have been crafted, and your fundamental rights are being interpreted to give intent to your human rights as well. So we are in an era of global constitutionalism, where international law recognizes certain enforceable rights which should be recognized by the domestic law. and you find that those enforceable rights are part of the human rights, international human rights framework. So courts have given respect for that also. If you look into the Jolly George Burgess case, which most of you might be knowing, with regard to whether a pauper can be put into civil prison for non-payment of his loan, the court interpreted Article 11 of the International Covenant on Civil and Political Rights, and the court said that a pauper cannot be put on behind the fetters since he's a pauper. He's unable to pay the amount back. So let's take it in a humanistic way. So you find that global constitutionalism has become the norm of the day. So, slowly the courts have changed, and you can't predict. We might in any way go behind what is happening in American judiciary. We might go into originalism also. So that's totally unpredictable. As of now, I can say that we are in the living constitutionalism mode, more or less.
Yes, ma'am. You have put it very correctly and clearly. I think we have Jayaprakash sir also. Sir is in US right now. So would you like to unmute yourselves and join the discussion, sir?
Okay, thank you, sir.
Thank you. Nice to see you, sir.
Sir, as you know, I am a layman as far as the intricacies of legal matters are concerned. But I fully agree with Professor Vani Kesari's voting for the living constitutionalism, because I think, if my memory is right, even the architect of our constitution, Dr. Ambedkar, said that a bad constitution can be made a good one by the right interpretation of a good judge, and vice versa. A good constitution can be made bad on by the bad interpretation of a judicial office, and that has been very well highlighted by the learned Professor Vani Kesari, and I fully agree with that. Even the appeal provision is there from lower court to the higher courts. That means there is no final word. It is a evolving process, and that is why the appeal provision is made. This is the points of view of a layman. Thank you, Rajesh sir, for organizing this very enlightening exercise and having a very scholarly person like Professor Vani Kesari for this intellectual exercise. Thank you, sir, both of you.
Thank you, sir. Thank you so much. It is our privilege that you have joined in spite of the
Okay, sir. Thank you.
Thank you so much, sir. I think we are also being joined by the Director School of Law from IGNOU. And if you are online, would you like to interact? If anyone else has any clarification to be made.
So there's another question in the chat box.
Okay, I will just see. The question is there any possibility to reintroduce Article 370 in the case of Jammu and Kashmir?
I think I'm not an apt person to answer that question.
I didn't take up this.
I'm an academician, so this is something very, very political in nature.
Definitely.
So I think I shouldn't answer that.
Yeah, sure.
But I think, I don't agree with the decision of the Supreme Court either on Article 370. That's my personal take on the decision. So that's it.
If anyone else has any intervention to make or any point of discussion, kindly unmute yourselves and ask the question or make your point. Okay, I think we have already had a fantastic discussion. It was wonderful that so many people, so many of our participants have been asking questions, expressing, putting forth their doubts, giving their interpretations, and taking forward the discussion, which has already been initiated through the presentation, so very well made by Vani Kesari madam. First and foremost, I should congratulate you for this wonderful presentation, ma'am. And many people are asking for your slides as well. So if you could share that,
definitely do that. I shall share it with your office.
Sure.
I will do that.
Once the program is over, we will share it.
Yes,
and
yes.
We'll share it as a kind of link beneath our YouTube presentation. From there, you can download it. So it should not be a problem as such. So it has been wonderful, ma'am. Wonderful having you for this discussion. In fact, many of the points of discussion went much beyond our expectations even. So it is definitely good to have such vibrant discussion. So before we close, it is our duty to express a formal vote of thanks for Vani Kesari madam and all those participated here. So for this, for doing
so before that, I should thank all the organizers, the regional center at Trivandrum, Dr. Rajesh and Shri R. Raja, as well as everybody over there who have participated in this discussion. I hope I have done justice to my job, the task given to me, and thank you for inviting me, and thanks to all the technical staff who have supported this event. Once again, thank you.
Surely, ma'am, you have done more than justice to what.
And thank you, participants, for your patient listening. That's it.
Definitely, ma'am. It was wonderful having you with us. And for doing the honors as regards the vote of thanks, let me welcome our Assistant Regional Director, Dr. Priya.
Good afternoon, all. Today we have organized this program as part of Constitutional Day celebration. And the topic we have selected for this webinar is also a relevant one. Not only on India, all over the world, there are a lot of discussions and debates are going on regarding these two concepts like originalism and living constitutionalism. Today, our chief guest, Dr. Vani Kesari, has explained every aspect of this, these two concepts in a very nice manner. On behalf of RC Trivandrum, I would like to thank Professor Vani Kesari for her wonderful presentation today. I also like to thank our Senior Regional Director, Dr. M. Rajesh, for creating such a platform for discussing such a relevant topic. Thank you, sir. I also like to thank Professor Dr. Jayaprakash sir and staff members and academics and staff members from various students. Sorry. And staff members from various regional centers and institutions for their participation in this program. Thank you very much.
Thank you, ma'am. It has been wonderful having this session, and I thank all the participants, and especially our resource person, Vani Kesari ma'am, for giving such a wonderful presentation. And let me remind our viewers that this Saturday, it's on 23rd at 11 a.m., we will be having another discussion related to the Constitution Week. And this time, our resource person is the sitting judge of Kerala High Court, Sri Shyam Kumar. He will be introducing you to yet another aspect of our Constitution and how judicial interpretations have worked in favor of strengthening the Constitution. That will be the area of discussion. So I'll request each and every one of you to join us for that session as well. It will be, I'm sure, another very, very memorable experience. And coming from the horse's mouth, it will give definitely another angle to how the Constitution is being interpreted by the courts across the country. So I hope each and every one of you will be present for that interaction as well. Thank you once again, each and every one of you, for joining us on this morning session.
Thank you, sir. Last but least, I would like to take a time to express about our examination. Is on 24 December examination. All tickets are going to out, which is already out. And it is requested students to need not to worry about the hall ticket, which is not received. Still, the work is going on due to our IGNOU systems are modifying it, so it is taking time. All are requested to check the IGNOU website and download your hall ticket for the December 2024 examination. This is the request. Thank you.
Thank you, Anna.